Thanks, Sarah, and we're in Melbourne, so we can call it soccer. It's either Melbourne, Canada, or the United States. We call it soccer. Sarah and I met in Amsterdam, and that's how this all happened. She was there studying, and I was there pretending to work. And FIFA, of course, is a very important organisation, partner with FIFA in the running of the game. We use the word partner advisedly. Represents over 65,000 professional footballers throughout the world. Today I thought I would touch on some key issues about athletes. I want to talk about fans and players, the perception and the reality, the mystique of sport, and the most important right for all athletes, freedom. Talk about collective bargaining, grievance arbitration, revenue sharing, because after freedom they're the most important rights for athletes as well. And then we'll talk about some of the challenges of today, anti-doping, match fixing. Then I'm going to introduce you to some guys who use the platform of sport to transform sport in terms of their stand for human rights. The guy on the left there is a fellow called Scott Fujita. He's a member of the management committee of the National Football League Players Association. And this year in the Washington Post, he wrote an important article as the Supreme Court paused to consider the question of whether same-sex marriage should be allowed. And he wrote as follows: "My 3 young daughters, like most kids, are curious and ask a lot of questions. My wife and I are as open and as honest with them as possible, but there's one question I'm not prepared to answer. Why aren't Claire and Lisa married? I don't know how to explain to them what inferior means, or why their country treats our friends as such. Sometimes people ask me what any of this has to do with football. Some think football players like me should just keep our mouths shut and focus on the game. But we're people first and we're football players a distant second. Football is a big part of what we do, but it's a very small part of who we are. And historically, sports figures like Jackie Robinson, Billie Jean King and Muhammad Ali have been powerful agents for social change. That's why the messages athletes send, including the way they treat others and the words they use, can influence many people, especially children." Marvin Miller, Executive Director of the Major League Baseball Players Association from 1966 to 1983, once approvingly quoted legendary baseball writer Roger Engel, and you'll get a theme from this, that I'm a pretty big fan of baseball and Miller. "Few fans resent a boxer earning $2 million for a single fight." Now, of course, it's many times that amount these days. "And they don't mind actors or rock stars raking in gigantic sums for a few weeks or even a few hours of work. They do, however, resent a baseball player being paid, say, $700,000 over a period of 7 months. Many fans think it's only an accident that they are not out on the field playing ball. After all, most people, at least most men, have played some form of ball in their lifetimes. There's an identification beginning in childhood that doesn't have a counterpart in the ring of music or film. And the relationship between the fan and the player is as true today in all professional sports as it was when Miller wrote his words in 1991 in his brilliant memoirs. The fan-player relationship, of course, at its best, is what makes the athletic career so special. It's personal. For the fan, was often once a player. And if he or she wasn't, it's likely that he had a son, a daughter, a brother or a sister or a friend who also played. The fan who relates to the player does so as the child who fell in love with the naive dream of being the next Derek Jeter, the next Gary Ablett, the next Lionel Messi, or the next Tim Cahill. Not as the adult who reached the pinnacle of a short-term and precarious profession where millions set out but only very few succeed. According to FFA, Football Federation Australia, around 1.7 million people participate in football or soccer. According to the PFA, there are 387 Australians who are pursuing careers as professional footballers, 178 Australians in the A-League, 145 overseas, there's another 34 young players overseas, and there's around 30 semi-professional Matildas. 0.02% of those who participate. Globally, FIFPro represents, as I just said, 65,000 players. FIFA estimates there are 262.9 million registered participants, 0.02%. The same is true for the all of sports. Unfortunately, the enormous talent of the athlete is often dismissed by the fan as being down to pure luck or an act of God. And sometimes that luck is also associated with a lack of respect on the part of athlete for his or her sport. The fan doesn't see the hard work that the athlete has put into becoming the player he or she is, nor the intelligence and the universally admired values that produce that player. Courage, teamwork, discipline, resilience, sacrifice, respect and love. Yes, a deep love of sport. Having worked with and represented professional athletes, and in particular footballers, for over 20 years, I see great merit in the famous work of Malcolm Gladwell and his 2008 book Outliers, in which he cites research by the psychologist Erickson on violinist and pianist from Berlin's elite Academy of Music. All elite performers, he found, had accumulated 10,000 hours of purposeful practice. That is, practice undertaken for the purpose of getting better. Future professionals had acquired 8,000 hours and future musical teachers 4,000. This is at the age of 20. Strikingly, Erickson did not find any naturals whose gifts put them in a higher group despite less practice, or any grinders who found themselves in a higher group because of more practice. You do the sums, 10,000 hours, that's 20 hours a week for 10 years, or 3 hours a day, from the age of 5 to 10 to be ready anywhere between 15 and 20 years of age. And having the intelligence at a young age to spend that time not only practicing, but practicing purposefully. There's 3 players who I've had the honour to work for who spring to mind. Harry Kewell, an apprentice professional at Leeds United at the age of 15. Mark Viduka, who was constantly warned to stop playing the ball against his dormitory wall at the Australian Institute of Sport until the early hours of the morning. And most incredibly, Craig Johnston, who designed his own training programs and routines after being rejected at 15 years of age for an apprenticeship at Middlesbrough Football Club. Within a few years, he was Britain's most expensive footballer for a time and a regular in Liverpool's dominant team of the 80s. FIFPro has research that shows that players identified by the football industry as having the talent to be professionals at the age of 18, 75% of which are out of the game by the age of 21. The average age of players today in Europe is 25.8 years. So the career of the player is indisputably precarious and by its very nature the province of the young. When it ends, players face a difficult transition. They often confront physical and mental health issues, which we'll talk about. They may not be educated or financially ready for life after football. The most important work of players' associations today centres on ensuring players are protected when injured and compensated if they suffer career-ending injury. It also centres on negotiating a fair share of sports wealth to be invested in career education and player wellbeing programs run independently by players for players. Sports are under no obligation to do this. Indeed, athletes are excluded from workers' compensation legislation throughout Australia. Athletes that do not have access to collective bargaining through a well-resourced and independent players association are not entitled to any legal protection when injured. Athletes, despite being full-time employees in most instances, are not covered by industrial awards like ordinary workers. And the performance of an athletic activity is excluded from the protection under the Copyright Act, despite the billions of dollars generated through the exploitation of that performance. In contrast, in the last 7 months, the Commonwealth Parliament has enhanced athlete-specific legislation in anti-doping that without the intervention of player advocates would have overturned an athlete's right against self-incrimination. Sports are now seeking the right to receive information obtained by police through their statutorily supervised investigations to enforce sporting rules in relation to match fixing. And whilst players' associations are at the forefront of the fight against corruption in sport, clearly serious questions arise regarding civil liberties, given that sporting governing bodies are not subject to any of the laws and the statutory safeguards that oversee the police. So why is the situation so unbalanced? That's what I'll consider with you today. Since the early 60s, there's been a battle that's been waged between the rights of athletes and the perceived interests of sports. Fortunately for those that love sport, decisive battles have been won by the players, whose leaders have better understood the law and the economics of sports. Free agency, for example, has not only legally emancipated the players but triggered an economic boom for sports. And without the courts and the law being on the side of the athletes, this wouldn't have been possible. As I'll explain, not only can sport accommodate the rights of athletes, it's much better off if it does. And I'll explore these themes by reference to some of the most important issues facing sport today, including the threats of doping and match fixing. Before I do, I want to touch on the structure of sport and the most important achievements of the player rights movement: freedom of movement, collective bargaining, independent grievance arbitration, and revenue sharing. The mystique of sport. The Europeans call it the specificity of sport. I call it a phrase, without any disrespect to sport's undoubted important social and cultural roles, as a legal ruse to violate the rights of athletes. One would naturally think that given the youth and the precarious nature of the athletic career path, sport would be in tune to the needs of athletes and the proactive measures taken to protect them. But ever since professional sport began in the 19th century, administrators have taken steps to regulate the movement of athletes in and outside of sport. And of course, sport has a unique structure. It requires two competitors to come together to produce the product. And that's what is the single justification for the imposition of many of the restraints on athletes. And there's also a view that when those two competitors come together, the result should be uncertain, it should be unknown. And that uncertainty of outcome will maximise the interest in sport. In simple terms, however, sports are structured as a cartel, and they can exercise enormous power over athletes. The most important right, freedom. Okay. Since the 19th century in professionalism, there's been a substantial number of controls imposed on athletes. The retain and transfer system. That meant that a player was retained to his club even though his contract had expired, and could only be transferred to another club if the club was prepared to pay a transfer fee. The reserve clause, which was a famous restraint in baseball, which we'll come to, bound a player to his club for life through an ability to continually renew an option in a contract of 1 year. So the contract would be renewed for 1 year, and the option would be renewed for 1 year. And then a year later, they would renew the contract and they'd renew the option, and so on and so forth. So a 1 year contract became a 25-year contract. Player drafts, zoning, permit rules, training compensation, the right of clubs to seek financial compensation when a worker or a player leaves. Homegrown player rules, rules which are designed to encourage clubs to field only homegrown players by mandating that. And what we're now seeing, point systems, including in the National Basketball League, where players are allocated a nominal point system, and every team must only contract a number of players without overriding that quota. And of course, salary caps. And today, the most contentious issue in professional team sports, particularly in the United States, is salary caps. And I'll go into some of the industrial action that we're seeing in and around salary caps. Might seem a little bit heroic to quote the great man, but freedom is never given to anybody. Privileged classes never cease, will never give up their privileges without strong resistance. Now, I'm going to introduce you to a gentleman by the name of Curt Flood. Curt Flood wrote a letter to the Commissioner of Baseball in 1970. The Commissioner's name was Bowie Kuhn. Dear Mr. Kuhn, after 12 years in the major leagues, I do not feel that I'm a piece of property to be bought and sold irrespective of my wishes. I believe that any system that produces that result violates my rights as a citizen and is inconsistent with the laws of the United States and the several states. It is my desire to play baseball in 1970, and I am capable of playing. I have received a contract from the Philadelphia club, but I believe I have the right to consider offers from other clubs. I therefore request that you make known to all the major league clubs my feelings in this matter and advise them of my availability for the 1970 season. Bowie's response, or Mr. Kuhn's response: Dear Curt, you have entered into a current playing contract with the St. Louis club, which has the same assignment provision as those in your annual major league contract since 1956. I do not see what action I can take and cannot comply with the request contained in your letter. Kuhn's rejection of Flood, expected as it was, began a genuine battle for freedom. And I'll introduce you to Curt Flood. When I take you through some of these athletes, I want you to ask yourself a question. Would you be prepared to sacrifice your career for a matter of principle? Which is what each of these players has done.
You're a man who makes $90,000 a year, which isn't exactly slave wages. What's your retort to that?
A well-paid slave is
nonetheless a slave.
If there's anything that I can ever do as far as this fight for freedom is concerned, certainly count on me.
Jackie Robinson was his Superman. He was his hero, his absolute hero.
Kurt Flood was a hell of a ball player.
If you ask me, would Kurt Flood be the kind of guy to sue baseball? I'd say no.
You will never have another job in baseball again, ever.
I realized that this is really a man of principle.
Curtis had a really hard life. He was a tormented soul.
He had tremors of his hand.
I didn't know where my father was. He was not available.
You're dealing with the nature of heroism.
I don't want anybody to own me. That belongs to me.
John Mackey, same time as Kurt Flood, became the founding president of the NFL Players Association. I was handed a piece of paper, a contract, and was told to sign it. Of course I didn't, and from that moment a youthful pique developed in me to fight for NFL players to choose for whom they work. Flood went on to lose his case. I'll come back to the reasons for that. Mackey won his. The first major victory for free agency actually came 50 years ago this year, in 1963, when the England international George Eastham and the PFA of England challenged football's retained transfer system. And it was about being an unreasonable restraint of trade. Eastham wanted to move from Newcastle United to Arsenal and was out of contract. He refused to sign a new contract with Newcastle and was retained by the club. In the words of the Newcastle team manager, Charles Mitten, as far as I'm concerned, Eastham won't be transferred. If he wants to play football, it'll be at Newcastle. Eastham learnt of this on the 30th of June 1960, the day his contract expired. He was not a playing, contracted or paid member of Newcastle United, but he was ineligible to play for anyone else. Ultimately, on the 13th of October, he began his legal proceedings, and ultimately his requested transfer was granted. It's interesting to think of the figures. £47,000 was the transfer fee. The maximum wage then was £20 a week. So if you look at the correlation between transfer fees and wages even today, what you see is clubs, for whatever reason, much happier and feel much greater ease in paying these huge amounts of transfer fees rather than spending that on wages. And when I spoke a little bit earlier about the mystique of sport, what happened in all of these cases, what these players faced, you saw with Flood, they wanted to get him out of baseball. That was the decision they made. And the same with Eastham. Eastham was fortunate, he was an international playing for England. He was in the squad when they won the World Cup in 1966. Secretary of the Football League, Alan Hardacre, he gave the argument you'll hear again and again. People in many parts of the country will quickly find themselves without a football club if the retain and transfer system is abolished. And you'll hear that today in the AFL, about free agency, the draft, the salary cap, all of it, that same argument. But Justice Wilberforce, and it's a very interesting judgment throughout the case. For example, Wilberforce commented, well, if the players are if the players are owned by the clubs, why aren't they on the balance sheets? This is in the 1960s. Why aren't they on the balance sheets if they're actually assets? And counsel for Eastham actually asked the Football League in Newcastle, why is that the case? And Wilberforce interjected and he said, livestock at valuation. It would look a little bit insulting. And Eastham's counsel replied, no more insulting than an individual than being brought and sold as cattle. But today, they are on the balance sheets of the players. And in response to this argument that the death of the transfer system would be the death of football, Wilberforce described it as an employer's system set up in an industry where the employers have succeeded in establishing a monolithic front all over the world, and where it's clear that for the purpose of negotiation, the employers are vastly more strongly organised than the employees. No doubt the employers consider it a good system, but that does not prevent the court from seeing if it goes further than is reasonably necessary to protect the legitimate interests. And so the first legal victory for the players was struck and the system was declared to be an unreasonable restraint. So why did Kurt Flood lose his case? Now, the laws are very similar in terms of their language. It's quite interesting. In Australia, it's an unreasonable restraint of trade test. That doesn't mean it's an absolute right. It's got to be an unreasonable question. And you can then establish reasonableness, e.g. it furthers a legitimate interest and doesn't go any further in doing so. Competitive balance, stability of membership, training and development. Very similar in Europe. And I'll take you to a very important European case shortly. And almost the same in the antitrust laws of the United States. So Marvin Miller of the Major League Baseball Players Association and Curt Flood in 1970 walk in to the Supreme Court of the United States to hear the judgment on whether he is going to succeed and the reserve clause is going to be declared, as the retained system was in Easton, to be unlawful. And Mr. Justice Blackmun opens his judgment. There are many names celebrated for one reason or another that have sparked the diamond and its environs and have provided tinder for recaptured thrills, for reminiscence and comparisons, and for conversation and anticipation in season and off-season. Ty Cobb, Babe Ruth, Tris Speaker, Walter Johnson, Henry Chadwick, Eddie Collins, Lou Gehrig, Grover Cleveland Alexander. The list seems endless. Yes, it was. He named 88 players. And one recalls the appropriate reference to the World Series attributed to Ring Lardner Sr., Ernest Thayers, Casey at the bat, the ring of Tinker to Eders to Chance, and all the other happenings, habits and superstitions about and around baseball that made it the national pastime, or in the views of others, the national tragedy. And Flood, at that point in time, with Miller, walked out of the court. That is actually part of the judgment, and if ever you've seen an example of the law being caught up in the mystique of sport, they held that baseball, because of a ruling in the 1920s, was not interstate trade or commerce. Because it was a game, it was not interstate trade or commerce. And they upheld a precedent from the 1920s, which drew on a precedent from even earlier. But the most crucial comment came in a dissenting judgment. Mr. Justice Marshall said perhaps an alternative legal path to resolving these employment disputes will be the National Labour Relations Act. And that's where baseball really became a famous sport in terms of the legal rights of players. Dennis Cuddy, you may know, Balmain and Australian Rugby League International. He challenged New South Wales Rugby League's equivalent of football's retained and transfer system. And Brian Dabschek, who's the leading academic in this area, describes Cuddy as an Australian hero. And his story is quite amazing. There are two extraordinary things associated with his case, which went to the New South Wales Supreme Court and all the way to the High Court, and still to this day is the leading authority on this point. The first one is, he and 3 other players stood out of the game for a season. One of those other players was Arthur Beetson. And he did not receive any financial or moral support from any other player whilst he did so. And secondly, he financed the case himself as an unskilled worker. The judgment is important for 2 reasons. It says what the legitimate objectives of the league are, and we've touched on them already. Strong and well-matched teams, and that in turn helps the players. But it also went on and dealt with transfers. And a second objection to the rules in their present form is in relation to the question of transfer fees. This is only another way of saying that an employer may restrain an employee from working elsewhere unless he is compensated for the loss of his services. And you'll hear that a lot in football even today, won't you? Hawthorn loses Buddy Franklin. Well, they should be compensated for the loss of his services. And people feel that quite genuinely, but in what other workplace does that happen? Silvio Fascini. This is the most important case in the AFL, because even though the authorities at the time said the courts should not advise in advance when a restraint is or is not reasonable, Justice Crockett did exactly that. And in declaring the permit and the zoning system to be unlawful restraints of trade in 1983, he said, listen, if the desire is as claimed to assist the less successful clubs becoming more successful by accessing talented players, I would have thought that a draft system would be preferable than the zoning system that you currently have. Now, what's important about all these cases as I rush through them is evidentiary. The evidence showed that the systems were operating counter to their stated objectives. The AFL was an uneven competition in 1983. 4 teams had won the premiership in the last 15, 20 years. the clubs were bankrupt. So these woes that were befallen, that were told to be befalling on sports, were actually happening. The other interesting thing about the Foschini case is even though the VFL Players Association was around at the time, his case was backed by St Kilda, and the VFL Players Association had no interest in it. And one of the most important issues you'll see in advancing the rights of athletes is to win one of these cases and use that as a basis for collective bargaining and to advance the rights of players in other areas. So, sports employment rules returned to the High Court of Australia in the 1990s, and the gentleman with the ball in that photograph is a guy named Kevin Ryan, a barrister, a former player for Canterbury Bankstown in the New South Wales Rugby League, and he became for a time president of the Association of Rugby League Professionals. I've not met him, I've spoken to him, apparently a very tough man. At question, the draft system. And Justice Wilcox, the right to choose between prospective employers is a fundamental element of a free society. It is the existence of this right which separates the free person from the serf. Now these aren't emotive comments by journalists, this is a comment from the full court of the federal court by one of the judges. And so today we have the NRL without a draft. And it's because of this case run by the players in the early 1990s. But the Players Association unfortunately collapsed after this case and was not able to benefit and capitalise on this legal victory as occurred in the other sports. In 1995 I had the opportunity to run a similar case for a friend of mine, Kim Taliadoris, who's the player in that photograph. He was then a Socceroo and the National Soccer League's leading goal scorer, and he sought to transfer from South Melbourne to Marconi when out of contract. The regulations stipulated that South Melbourne would be entitled to a compensation fee worth several years' salary for the training and development of Taliadoris, even though he was clearly a finished product. We campaigned very hard around that. There was a Four Corners program, and you may recall, for those who were around at the time, that the ASF, the Australian Soccer Federation, commissioned the former Supreme Court judge and NCA head, His Honour Don Stewart, to investigate Australian soccer, and he famously issued a report that quoted Shakespeare's The Tempest and that only a sea change could save Australian soccer. Well, that sea change did come, probably a decade or so later, but when we challenged this system before the Industrial Relations Commission, which we did because it was a cost-free jurisdiction and we couldn't afford to lose in the Supreme Court because we didn't have any money, the bench basically said this system operates unfairly towards players and has little, if anything, to do with the training and development of players, which was its stated objectives, and so the system should be abolished. In my view, these systems are largely about control. There will be a lot of statements put forward as to why they exist, and a lot of evidence put forward about competitive balance and economic viability. But here, over a period of 30 years, we have consistent judgments, all in the way of the players, about these systems not only not achieving their objectives for sport, but violating the rights of players. Now, the most famous case of them all is a case which was funded by FIFPro, Bosman, and the Bosman ruling is now in the vernacular of football. In 1995, 6 months after our victory in the case for Taliadoris, the European Court of Justice declared that footballers have the right to move freely within the European Commission, and that the claims to training compensation violated that. And the claims and the quota rules also that limited the number of foreign players from within the European community also were discriminatory and had to be abolished. Now you can imagine at that time people said this will be the death of football as we know it. Now of course the European leagues have been globalised. They celebrate the foreign players that play in their competitions, and players move freely. Okay. One of the important things about the Bosman ruling that's not known is the view of Advocate General Lenz, And because the whole question has always been, if you're going to abolish this system, what are you going to replace it with? Well, if you look at the NRL, the answer is you can actually replace it with nothing. The NRL is a very competitively balanced competition, and obviously there's an issue there with salary caps, which we'll come to. But Advocate General Lenz envisaged a solution of revenue sharing between clubs. And he said part of the income obtained by a club from the sale of tickets for its home matches could be distributed to other clubs. Similarly, income received from awarding television rights could be divided between the clubs. And the Advocate General pointed out the material interdependence that exists between competing teams. Each club, he suggested, needs the other in order to be successful. For that reason, each club has an interest in the health of the other clubs. If the league is to be dominated by one overmighty club, then that lack of interest will spread. So it's a very important notion, the question of revenue sharing with players or revenue sharing between clubs. And in the United States, it's the single biggest area of dispute in professional sports at the moment. Now, there's been less litigation through the courts in professional team sports in Australia football and the United States since these cases, and the reason has been the emergence of the players' associations and the advent of collective bargaining. If we go back to Major League Baseball, Marvin Miller, in negotiating the first collective bargaining agreement, insisted on a thing called grievance arbitration. Miller, being from the United Steelworkers Union, knew this was a standard condition in US labour relations. It simply meant that disputes would be resolved by an independent arbitration through a panel or by an arbitrator appointed by the union and management. Management ultimately agreed to this in baseball, provided the Commissioner of Baseball retained the power to rule on matters related to the integrity of the game. At the time, Miller said management agreed to grievance arbitration. They didn't see the eventual cost to them of this non-economic issue. But this victory was as important as any we would win. Any collective bargaining agreement which can't be enforced by binding, impartial arbitration isn't worth the paper it's written on. And in addition to ensuring enforcement, grievance arbitration can lead to the development of a sports-owned jurisprudence. And this is how Miller won free agency, ultimately, for baseball players, through these two guys, Messersmith and McNally. Clause 10A of the Uniform Players Contract basically said a club may tender to the player a contract for a term of that year, and if the club and the player don't agree, then on or before 10 days after March 1, the club shall have the right to renew this contract for a period of 1 year on the same terms. So having lost the reserve system, having taken flood, totally transformed that man's life. In fact, today, Flood died a few years ago, and in the resolution of the 1994 strike that saw the cancellation of the World Series, some legislation was passed by the Congress that removed baseball's antitrust exemption in respect to the labour market, and that legislation is now known as the Kurt Flood Act. But going back to this very simple situation, Miller had a simple view. He said the contract says you can renew it for 1 year. That's all. And so, with independent arbitration, commissioner arbitrator seats found for the players. And with such a simple decision, so collapsed the reserve system. Now, Miller's an economist, and the first thing he did after that legal victory, which no one saw coming, was to agree to reduce the supply of free agents on the market. And he agreed that the reserve system would apply for the first 6 years of a player's career. Why? Oversupply in the market, simple, undervalues the assets, undervalues in the law of supply and demand. And since then, players' salaries have soared, but so too have the economics and profits of baseball. And I've got here a brief video which talks about Miller's legacy on baseball. The guy who gives it is a bit of a character, and it really summarises in many ways the importance of freedom and the economics of sports.
We are at the end of the first Labor Day without Marvin Miller since 1916. You may hear that name, Marvin Miller, and recoil. This is why you should hear that name and thank his memory for almost everything you enjoy about sports today. And this is why all the owners in all the leagues in this country should name their stadiums after him. If you don't know him, he was the executive director of the Major League Baseball Players Association from 1966 to 1983. And he was described as, along with Babe Ruth and Jackie Robinson, one of the three most important men in baseball history, described that way by no less an authority than Red Barber. And he was still so despised by the old-time baseball plantation owners that when Marvin Miller just missed election to the Hall of Fame in the vote of its members' players in 2007, the Hall of Fame changed its rules so that his candidacy would no longer be voted on by ex-players, but instead by 3 players and 9 guys who weren't players, including the sons of 2 former league presidents whose lives Miller made hell during the 60s and 70s. Marvin Miller died last November without getting to see himself elected to Cooperstown. As I noted in a piece for MLB.com, from which some of these remarks are drawn, this season, $10,000 will buy you 8 front-row tickets to 1 regular season game at Yankee Stadium in New York. In 1966, $10,000 was the average salary of a Major League Baseball player. 1966 is not ancient history. Bruce Bochy was already playing Little League. Reggie Jackson and Johnny Bench and Nolan Ryan were about to hit the majors. Inflation since that year has not been 7,500%. Yet in 1966, to get the Dodgers to pay Sandy Koufax just $125,000, Koufax and Don Drysdale had to threaten to sit out the whole season and become actors. And Marvin Miller changed all that. You can argue that the pendulum Marvin Miller unleashed from its artificial restraint has swung too far to the other side. You'd be wrong. Who signed a $6 billion television contract? Clayton Kershaw or the new Dodgers owners? You can also argue that free agency and everything else Marvin Miller accomplished has created that bill for $10,000 for 8 tickets at Yankee Stadium, and you'd be wrong yet again. As someone long ago observed, this assumption requires another assumption, that the owners would never, ever have raised prices if there hadn't been free agency, and that doesn't hold up, because pre-Marvin Miller, the owners had quadrupled ticket prices, while player salaries had barely doubled. You can also argue that Marvin Miller hurt the owners and the fans, and in this you'd be the most wrong yet. In 1966, it was believed, even by players befuddled by a century of Stockholm Syndrome, that to let Marvin Miller erase the reserve clause, the one that bound every player to a team for life, that would unleash the destruction of competitive balance. There was no competitive balance to destroy. In the 18 seasons before Marvin Miller, the Yankees had been in 15 World Series and the Dodgers in 9. And the first team in Kansas City had finished last or in the bottom 4 all 13 years it was in Kansas City. It was claimed that Marvin Miller would end franchise stability and all the small market teams would have to relocate. There was no franchise stability. In the 19 years ending in 1972, 10 franchises moved. In the 41 years since, 1 has moved. It was believed then that Marvin Miller would literally cause teams to go out of business. The day he got his job, there were 20 big league teams. Today, there are 50% more. It's Labor Day, and the players should have held a moment of silence in Marvin Miller's memory at every game today, and every owner should have joined it. An anecdote told by then Dodger Vice Presidents Buzzy Bavasi and Fresco Thompson indicated that the Dodgers made $6 million in 1963 and $4 million in 1964. The Dodgers, the Los Angeles Dodgers, made then what Mike Pelfrey of the Twins makes now for going 5-10 with an ERA of 4.86. The Dodgers and everybody else went from there to tens of millions, then hundreds of millions, then to billions. And that's directly attributable to the new economics that Marvin Miller unleashed in baseball, in all sports. He personally put the word billion into baseball. Miller once admitted to me that he did not foresee the intangibles that the liberated player would create. Who could have known that player contract negotiations and the covering of them and the kibitzing about them would become an industry that would rival coverage of the game on the field itself? There's no off-season anymore. There is a winter spent speculating about free agents and contracts and putting teams together. And that created fan interest in the science of putting the proverbial dollar sign on the muscle. And that produced Saber and sabermetrics, and for that matter, it produced fantasy baseball and all of fantasy sports. And almost none of this came up in the conversation I'd had with Marvin Miller 10 days before he died. He was still talking about one word in all its forms: freedom. Freedom was Marvin Miller's original goal as the head of the Players Union. Freedom from the nonsensical Supreme Court decision that because baseball players played a game, their bosses were not truly running a business. And thus, a 17-year-old kid who signed a 1-year contract with, say, the Philadelphia Phillies was actually signing a 25-year contract. Each one-year agreement had a clause allowing the owners to renew the contract for just another year. But the renewed contract also had the renewal clause, and that contract could be renewed forever. It wasn't actually slavery, but it sure as hell wasn't freedom. And that one word, freedom, that was what Marvin Miller was all about.
We did the same deal in football after the Bosman ruling. Players free from the age of 23, independent grievance arbitration, introduced at a global level. What that means is that any player who has a labour dispute of an international dimension can go to FIFA and get that arbitrated by an independent arbitration panel, chaired by someone appointed to by FIFPro and the clubs on the one hand, with representatives of FIFPro and representatives of the clubs. Through that, we've now developed an entire jurisprudence that protects players throughout the world. Irrespective of the clauses in the contract cannot be terminated for performance. A contract cannot be terminated because a player is injured. Clubs that don't pay players will have to pay compensation, and players in those circumstances can move freely. Unilateral options are prohibited, for example. And we've seen also, of course, an enormous growth in players' salaries. But what I can say in football today, the biggest problem is the non-payment of the salary. We have a case of economic haves and economic have-nots, and it gets back to this refusal, as recommended by Advocate General Lenz, for there to be greater sharing of wealth and greater sharing of revenues throughout the football world. If we go back to the United States, where we now have revenue sharing with players, we can see that with a salary cap is important in the NFL, NBA, baseball, hockey and soccer. So apart from baseball, I beg your pardon. Now what we have, the modern statement of Wilberforce's monolithic front, is the lockout. And so what we're seeing, in order to reduce the players' share of revenue, are employer-instigated lockouts in all of the major sports apart from baseball. And there's only one reason why it doesn't happen in baseball, and that's because the Players' Union stopped the World Series in 1994. And the way the law works in the United States is you can bargain to an impasse and then you can instigate a lockout. And then if you still don't reach an agreement, you can replace the workers. It's a pretty tough system. And after the 1994 World Series was cancelled, 95 season began, they tried to replace the players, but even then the union stood out. It's an incredible element of strength, and it's the only reason why now in baseball there's no salary cap, and there's a big emphasis on revenue sharing between the clubs. And we're going to see this in the AFL. This will be the debate. Why do the players have the restraints? Why is there a cap on their earnings when the clubs and the league are not sharing revenues to a much greater degree among themselves, basically giving the lesser clubs a greater capacity to compete rather than simply putting the burden of equalisation onto the player. I'm cognizant of the time, so I'm going to quickly finish up on the challenges of corruption and cheating so we can have a few questions. But I believe that those fundamentals that I've set in place, those four things, are actually the answer to player rights when it comes to corruption and cheating. And that's why I wanted to spend some time going through them. If we look at the issue of WADA, obviously there are major athletes' rights issues. It's a strict liability system. There are mandatory penalties. The athlete is responsible for whatever enters his system. If the athlete is given wrong medication and takes a prohibited substance, the commentary to the WADA code actually says, well, the athlete is responsible for the selection of his doctor and for the advice given to his doctor not to take a prohibited substance. The issue is clearly an important one, but you're dealing with a global organisation that has incredible political power. And so the power that I spoke about in terms of Eastham and all of that is as relevant when it comes to WADA. The issue for us is clearly a human rights issue. But more so, why should these, and it gets back to all the cases I've just taken you through, why should these restrictions be accepted when they're ineffective? And that's really a point that we're trying to get across. David Howman's a New Zealander. I'm very close with his brother, who's one of the leading player rights activists, believe it or not, in New Zealand, Andrew Scott Howman. Statistically, the numbers of people being caught is between 1 to 2%. That's the number of positives against the number of tests, but the number of doping are in the double digits. That's according to David Howman. I've asked David, when you say double digits, what's that? 10, 11, 0.1? What's double digits? He says it doesn't have a 1. Doesn't have the first digit's not a 1. So what's that, 20, 21, 22? What is it? It's not a 1. Where do you get that from? Oh, we can't really share that with you. It's a huge statement. That means there's 13,000 footballers doping. 13,000 footballers are doping. Now, Unisport Pro is the World Athletes Federation, which we're trying to organise. WADA does not publish consistent data on the test results. But what we know is this. Of those that do, 277,000 tests were conducted in 2009 and 758 were positive, 0.27%. 258,000 a year later, 1,300 positive, 0.53%. 3 out of 2,216 out of competition tests were positive, 0.13%. That's what justifies the athlete's whereabouts system. That's why athletes have to tell the authorities where they're going to be every day, because testing out of competition will eradicate doping. Touch on match fixing. FIFPro issued a black book in last year, and Australia has a good policy on match fixing. It was adopted in 2011, and it was a very collegiate process involving the governments, the sports and the players' associations, and we're seeing that legislation in Victoria, and it became relevant a week ago, where we actually have match fixing as a crime, which is very important because we know that it starts with betting, it starts with organised crime, and it's about people who want to make money, have no interest in sport. Athletes are clearly corruptible, but we say at FIFPro that the athletes are not responsible for the, well, let me rephrase it. The corruption does not begin with the athlete, it ends with the athlete. That's the way we see it. So we want to do whatever we can to protect the athlete. FIFPro's Black Book looked at players in Eastern Europe, and the two real hotbeds for match fixing are Eastern Europe and much of Asia. 41% of the players are not paid on time. 5% have to wait more than 6 months for their salaries. Who can do that? Who can honestly wait more than 6 months for your salary? Every 9th player has been the victim of a violent act, and a majority of those are from within the club. Bullying and harassment, racism, discrimination, and nearly 12% say that they've been approached to consider fixing the result of a match. And more than double that number are aware that match fixing takes place in their league. Now, you'll hear phrases such as zero tolerance, lifelong bans. I went to a conference in Kuala Lumpur where the president of the AFC got up and said, we have a zero tolerance approach to match fixing. I said, well, why is it then that you allow the clubs to get away with not paying the players? And you don't have any system to enforce that? How can you say it's zero tolerance when you're not taking those basic precautions to protect an athlete from being corrupted? And just before I finish and open a few questions, I want to talk to you about when athletes transform sport. Players' associations are human rights organisations, and they're proudly human rights organisations. And I just want to share with you one of the very important issues, what Scott Vegeta wrote about the rights of gay and lesbian athletes, and just share with you something which the National Hockey League Players Association is doing at the moment.
If you can skate,
you can skate.
If you can shoot,
you can shoot. If you can score,
you can score. I'm Brian Burke, General Manager of the Toronto Maple Leafs.
And I'm Patrick Burke, Scout for the Philadelphia Flyers. Before my brother Brendan passed away in 2010, he was the first person to fight for the rights of gay athletes in professional hockey. Since his accident, our family has fought hard to carry on his legacy and ensure that LGBT athletes around the world are afforded equal opportunity, judged only by their talent, character, and work ethic in their sport.
We're now joined by hockey players from around the world supporting my son Brendan's simple message.
If you can play,
you can play.
If you can play,
you can play.
If you can play,
you can play.
Billie Jean King is a legend of the women's tennis circle, and I just cannot understate the courage that each of these athletes have demonstrated. On Friday was the 20th anniversary of the Battle of the Sexes matches. You may have seen that, between Bobby Riggs and Billie Jean King. And the Washington Post was writing about it. They said, you know, often the participants in culture tilting moments look back later and say they never realised at the time how big it would be. In the words of Billie Jean King, I knew how important it was. I did know, I felt it, I knew it was the moment I said yes to Bobby. I remember saying then it's going to touch the emotions of our preconceived ideas about gender and the culture we live in. And I thought it would set us back 50 years if I did not win the match, and it would have ruined the women's tour, and it would have affected all of women's self-esteem. And as we now know, she won. King established the Players' Union, which became the Women's Tennis Association. She established equal pay for women in tennis. She became the first woman athlete to earn $100,000 in a year. She established Women's Sport magazine, the Women's Sports Foundation, and after admitting her bisexuality in 1981, lost millions in endorsements. She believes she was born with a destiny to work for gender equity in sports. Life magazine voted her one of the 100 most important Americans of the 20th century, not American athletes, Americans. 4 athletes made the list, including Muhammad Ali and Jackie Robinson. And we have our heroes at home here in Australia: Kathleen Freeman, Michael Long, Nicky Winmar, and I put Dennis Tutty and Kimon Taliadoris into that category. Individuals willing to sacrifice a career for a principle. The last video I'd like to leave you with is the late great Peter Norman. I'm not sure if you're familiar with him. Have any of you heard of Peter Norman? Yeah, fantastic, because a few years ago a lot of people hadn't. And here's just a 2-minute video on his contribution.
Widespread racism and bewilderment are the seeds of the revolution.
Violence and hatred are the attributes of a sick society.
Who the hell's he?
Peter Norman is flying on the outside.
I guess I'd just like to be thought of as an interesting old guy.
There were 2 Olympic teams. There was the white athletes and the black athletes.
Don't think any of these boys will be foolish enough to demonstrate at the Olympic Games.
Nobody knew what it was going to be.
All I can say is you can expect almost anything.
I was just sick.
For him to take a stance during the Black Revolution from Australia, I thought that was fantastic.
There's this guy from Australia called Peter Norman. Who the hell's he?
A new Olympic record to Peter Norman of Australia. Peter Norman easily third.
Every time he stepped on the track, he was running better.
This is the hottest 200-meter field ever assembled.
Peter Norman is an enigma to me because he came from nowhere.
This was life and death.
They said, you're not in the team. I believe in human rights.
No way somebody I never heard of from Australia was going to split them up.
I'm sick to death of hearing your anthem.
It's a pleasure for me to know Peter, and it's a pleasure for my people to know Peter Norman.
And if you have something to say, you have to say it. You can't wait and say, I wish I'd said that. I wish I'd done that.
I think this will be an area of intense focus of player associations over the course of the next few years. It's been a matter where we've been happy in many instances to leave with medical experts. But you see, in football or soccer, we've not had a straightforward process, for example. We had a lot of trouble with the implementation of minimum medical standards. And it wasn't until we published injury rates and then put a financial cost on those injury rates over the course of a 5 or 6 year period were we able to get minimum medical standards into the collective bargaining agreement. And then they saw a correlation not only economically, but in terms of on-field position. Well, you know what, if you've got a lower injury rate, you're a chance to win more football matches. Once that penny dropped as well, not so much with the coaches, but with the owners and the people that run the clubs, then we've now got them coming to us. I was just saying to Annette before, that we now have to have concussion guidelines in our CBA, which we're introducing. And I think there's going to be a whole lot of other areas. Heat's a big issue. I was just at the FIFPro board meeting last week, and we're saying, can we play a World Cup in Qatar? What should our position be? FIFA standards on heat are much poorer than what we would accept in terms of heat here in Australia. In the A-League, our policy is much more committed to player health and safety than what FIFA's is. So I think with Essendon, it's a very interesting matter. But what are the principles? What I tried to show with that presentation is that whenever athletes have to advance their rights, they have to get it away from the mystique of sport. That's really the whole tactical imperative. And that's why the courts were so important. And apart from the Supreme Court in flood, the courts have helped the players. But now, with grievance arbitration and with the political powers of sports, it's very difficult to do it. If you deal with WADA, for example, right? WADA is pretty much a non-negotiable. I sat down with Kate Lundy when she was the Minister for Sport and said, we've got concerns about the effectiveness of WADA. She says, well, we can't consider our involvement with WADA. So, well, can't we make it better? No, we can't do it. So unfortunately, the mindset's not there, and this is all because of the politics. So you have a mandatory penalty, and where do you appeal? You appeal to the CAS. And what does the Court of Arbitration for Sport do? It upholds pretty much what the WADA Code says. So our ability to take these things outside of the courts is greatly weakened. And that's bad for sport, because what these cases show is that when the athletes stood up for themselves, sport was better off. And WADA's not accountable. When we've tried to set up the Players Association, the World Athletes Association, we got the minutes of the WADA Foundation Board, which is Dick Pound and John Fay. And those minutes are reprehensible in what they say. We cannot give this organisation any oxygen. We cannot give this organisation any credibility. Who do they think they are? They think they represent the athletes. Yeah, we do. We're democratic. We represent the athletes. No, we appoint our own athletes commissions, and they represent the athletes. So that's the political power. And so this monopoly that we brought down in the 60s and the 70s and the 80s, it's back. And that's the problem with WADA. Now, I spoke to Richard Ings the other day, and I was actually at this very interesting conference with Ben Johnson. And what Ben was telling me in particular about doping and about the Jamaican side is very, very concerning. They were not target tested. The Jamaican athletic track and field team was not target tested in the lead up to the Olympics. And so what we've said is testing is ineffective. We must go towards investigations. That's fine. Let's have fairly balanced investigations. But we can't do that because ASADA is too scared to say, well, look, next year we're going to have 30% less tests than we had last year, but we're going to have more investigations and we'll have a more effective regime. They don't think people will accept it. So at this stage, no one's willing to change. No one's willing to make the system more effective. And you can't legally challenge it. I don't think that's healthy. And maybe, I think it's an unreasonable restraint. I think a mandatory penalty for an inadvertent doper for 2 years is an unreasonable restraint. It clearly goes further than is reasonably necessary. Whether you can get a player who's prepared to sacrifice a career, that's the problem with the restraint and trade doctrine, which I tried to show. All these guys sacrificed a career, all of them. And that's the problem. You need someone who's prepared to do that to bring about change, and players' associations are meant to be able to prevent that from happening. As far as the specifics at Essendon are concerned to this, I know nothing about the particular facts, but if a player is convicted of doping because he has such limited defences available to him, then I think there's absolutely no doubt that the club has breached its legal duties to the player, and that the club will be facing compensation and should compensate the player. And I know WADA wants 4-year bans, but my experience for the overwhelming majority of players is a 12-month ban is career ending. Yeah, look, we never push a player into making a stand. We advise them as to what the rights and their responsibilities are, what the cost is. And then every now and then you get a player who's prepared to stand up, but they're rare. They're rare because they don't want to lose their career. And that's unfortunately what's required. And Miller did the same in advising the baseball players. They could have settled. They could have settled Flood. Messersmith and McNally, they all could have settled. But once it becomes a principle, you're dealing with young men who are competitive in baseball, for example. So once they turn it into a contest, right? Once it becomes a contest, they're very formidable negotiators. And so what we do, which I didn't touch on, is we always have players in the room in the negotiations. Major League Baseball in their last negotiation involved over 200 players, right, across the table. We involve them, and it's amazing how different the owner and management's behaviour is when you've got players in the room. When they're not in the room, they're aggressive. What are you trying to do? Ruin the game? Who are you? Right? Players in the room. How are you today? Would you like a cup of coffee? So it has a huge impact. Curtis Granderson, the centre fielder for New York Yankees in Major League Baseball, personally attended over 16 bargaining sessions in their last CBA. So players will take a stand that way. To be that test case, the situation in Bahrain is very complex, and I do a lot of work in Asia, and we had players actually come and play in our A-League because what happened, just like and it's very important, in Bahrain, and we've seen it in Palestine as well, the players are targeted because they're famous athletes. So just like a famous athlete in a Western country will get a sponsorship endorsement, in these countries they will be targeted for not speaking, to make sure they don't speak out. And that was the situation and a player who played in A-League for that 12-month period of his suspension. I think the need is to do so is gone. It happened regularly when I started in the mid-90s. But when we brought that case for Taliadoros, we had another player, John Kosh, who missed 3 years of his 6-year career because of transfer disputes. The Mackey case was because NFL was not exempt from antitrust and baseball was, so we won quite easily. But it's an interesting thing, they didn't convert that as well as what the baseball players did. The baseball union would be regarded to be much stronger than the NFL. Whether we have industrial action here, what we do know is this: our laws at the moment preclude an employer-instigated lockout. So you can only lock workers out in response to industrial action by the players. Now, we've never gone down that path, it's never happened, we hope it won't have to happen. Players have to remember, and we advise them, because they do get they're very educated. So guys, if you want to miss a day, they can lock you out. Now, we don't have the strike funds, and we don't have, Major League Baseball's got a $250 million strike fund. So there's a lot that goes into administering and running those strikes. And the NFL was a lockout by management, not a lockout by the players.
Thanks, Brendan. My name is Dennis Hemphill from Victoria University. I'd just like to return to the Essendon case again.
Sure.
Do you think the charges that were brought against the coaches and the team doctor, which has subsequently been thrown out, marks a weakening of the strict liability clause of Asada and Wada?
No, I think there's two issues. I think there's clearly two issues. One is whether there's been infraction notices or a breach of the anti-doping code. I hope the players are not charged. I think it would be very unfortunate. I think there seems to be enormous sympathy for the players that they were very poorly managed. And I hope that that's the instance. I do fear for them if they are charged, because I know how difficult WADA and Asada are, or Asada is very, very difficult. I think, however, there's enough information on what's available in the media, and clearly I haven't seen the documents, to say that they acted in conduct prejudicial to the interests of the game. What did they do? They implemented a regime which wasn't properly documented, which could have subjected the players to not only medical harm but also very significant legal consequences. And they did so for the purposes of a competitive advantage. And then you ask yourself, is that the type of conduct you want in your competition? And I think the Commission's well within its rights to conclude that it doesn't. And I think the Players Association have been very strong, and they've said, look, this is a player welfare issue. And I think it's a sporting issue. So I think they're discreet. I think there's absolutely no difficulty whatsoever with the AFL having done what it's done. And then the door remaining open. And as I said, I hope the players are not charged, but that door can remain open. It's a separate legal issue in terms of any liability under the ASADA code or the AFL anti-doping code.